morning, everyone. Welcome to this debate, and thank you so much for being here. I am absolutely delighted with this panel today to discuss the new bill with a proposal for a new commercial code in Brazil. We couldn't have better panelists to discuss this theme. We are so lucky to have here Professor Fábio Ulloa Coelho, who is the author of the bill and the idea of a new commercial code. To Brazilians, Professor Fábio Ulloa Coelho needs no introduction, but I'll just say a few words given that we have an American audience as well. Professor Fábio Ulloa Coelho is, I think that's really not controversial, the most cited and best-selling author in commercial law in Brazil, and at his point of his career, he's very much enthusiastic about the idea of a new commercial code in light of improving the Brazilian institutional environment when it comes to private law. We also have here Otávio Yazbek, who has recently stepped down from his post as commissioner at CVM. Yesterday, we also had here Luciana Dias, and Otávio and Luciana together are very much known as some of the brightest minds that have really played a very important role in the commission in the last years. He's now back to private practice, and in the last years has written about this proposed bill with great interest. And we also have Flávio Sodré, who is the head of corporate and M&A in Ambev. And we were at Ambev yesterday with Stanford students and faculty, and Ambev is a firm that, led by Flávio, has played a very important role in the private sector and debate concerning this project. So really, I'm so happy to have you here, and I'm really looking forward to the debate. In terms of format, Professor Fábio Ulloa Coelho will start with a 20-minute presentation, then we'll have the perspective of a regulator and practicing lawyer in the private sector in Otávio, and then Flávio will make his consideration, and then we will open it up for debate. Thank you.
Good morning. First of all, I would like to thank Professor Par Gendler for the invitation to take part in this panel about the Brazilian Commercial Code Bill. My compliments to Professor Yazbek, to Mr. Sodré. I will talk about the adversaries and the enemies of the new Brazilian Commercial Code movement. First, I would just like to point out to our guest that in Brazil, commercial law is a very vast concept that encompasses several legal branches, such as corporate law, business contract, debt notes, bankruptcy, intellectual property, unfair competition, e-commerce, and maritime commercial law. As a civil law jurisdiction, Brazil has followed the tradition of grouping the legal regulation of several matters into extensive and systematic legal acts, named codes. This tradition began in France more or less 200 years ago. Currently, the Brazilian commercial law is spread out over several legal acts, including two codes: the Commercial Code, enacted in 1850, the Civil Code from 2002, the 1976 Corporate Law, intellectual property laws enacted during the 90s, the 2005 Bankruptcy Law, etc. The Commercial Code Bill aims to consolidate the legal regulation of the economic activities, but its most important objective is a different one. It's to help the improvement of the Brazilian business environment. The commercial code has opponents. Of course it has. Truly, every new law, any new law, will undoubtedly have opponents. Why? Because any change in law benefits some people and damages others. It's absolutely inevitable. Any new law will benefit a part of the society, and it will harm the interest of another part. Law establishes a balance between interests in conflict. When this balance changes, some interests are consequentially no longer protected as they were. And an important bill like the Commercial Code is introduced. It threatens the interests of some people. Since harm is inevitable in any new law, we need to pose the question, in a democracy, how can we say that a new law is good or not? The answer is, a law is good when it benefits a quantity of people superior than the quantity of people it harms. 100% consensus is impossible, except in a few and simple cases. Congressmen always arbitrate conflict of interest when they discuss and approve a new law. So, the existence of opponents against the Commercial Code shouldn't surprise anybody. It's natural. The lack of opponents would be astonishing. In fact, the inexistence of opponents would strongly suggest the irrelevance of the law. There are two categories of opponents: the adversaries and the enemies. They are allied because both of them want to impede the bill. But there is a significant difference between the two. Adversaries are the opponents whose interests are not threatened by the new law. The opposition derives from a different opinion on the best way to face the same questions. Enemies are the opponents whose interests are threatened by the new law. Adversaries eventually change their opinion and become a proponent. Enemies don't. The enemies are much more motivated to fight against the approval of the bill because they think they will lose. Now, I would like to refer to two adversaries. First, the study of Professor Luciana Yeong called Measuring the Impacts of the Commercial Code Bills. I will refer to this study as Luciana Lucianos because she is an economist and asked for the collaboration of a legal professional, Professor Luciano Tim. He helped her by providing legal information. Unfortunately, some of this legal information was totally inaccurate. The objective of Luciana Luciano's study is to calculate the amount that Brazilian corporations would spend with the commercial code. According to them, the commercial code would cost dozens of billions of reais. Luciano's study is not a complete evaluation of the impact of the commercial code, because they don't estimate the benefits it will bring to corporations, consumers, and workers in Brazil. They are focused exclusively on the cost. Nobody knows the reason of such option, but we cannot forget that they are adversaries. Anyway, this study adopts incorrect premises. Luciano presupposes the economical irrelevance of the content of the law. According to this study, the cost of a new law could be calculated simply related to the number of articles it has. Each article would cost 120,000 reais. According to Luciano's study, any law with 10 articles would cost the same amount, regardless of its content. For instance, a hypothetical law that strengthens the solidness of the contracts would have the same cost of other hypothetical law that abolishes the security exchange market in Brazil. Any legal act with 10 articles would cost 1,200,000 reais. Luciano's study doesn't explain the grounds of the premise of the economical irrelevance of the content of the law. We cannot accept this premise. Consequently, we cannot accept the calculation from this premise. In fact, the adequate methodology to evaluate impacts of law is the subject of several studies in prestigious institutions around the world. Last year, in London, I attended the meeting of the creation of the Global Society of Empirical Legal Studies. Cornell Law School, College London, Max Planck Institute, Hebrew University of Jerusalem, National Law University Delhi, Academia Sinica of Taiwan, Universität Hamburg, and Universidade de Torino were represented there. Brazilian Jurimetric Association was the only Latin American institution invited to this meeting. As the president of its scientific council, I took part in this historical event. I can tell you, I can assure you, despite our best efforts, there is still no consistent methodology that permits the highly complex calculation of all the impacts of a new law such as the Commercial Code. Nobody simply knows the true answer. Surely, I'm not talking here about the methodologies created to calculate the impact of specific rules made by specialized authorities in some fields, such as telecommunications, drugs, insurance. In the United States, this calculation is mandatory, and there are consistent methodologies for this purpose. I'm talking about methodologies which are much larger subject. I say that until now, nobody knows how to calculate all the impacts, benefits, and costs of a very complex law like a code. The second adverse study I point out is the limited liability company Radiography. This study was conducted by Professor Matos Filho. I will call it FGV study. The objective of the FGV study is to identify the average limited liability company in Brazil. First of all, I would like to explain to our guests that the Brazilian LLC was inspired by the Gesellschaft mit beschränkter Haftung. But, contrary to the German LLC, the Brazilian LLC has also been adopted as the legal entity of large investments. For instance, Ford, General Motors, and Microsoft are LLCs in Brazil. The Brazilian LLC serves as a legal instrument of a very large range of businesses. More than 95% of the companies in Brazil are LLCs. The FGV study tries to identify the average LLC. According to its measurements, the average LLC is a small-sized company with just 2 partners. So, the FGV study jumps to conclusions. The commercial code would not be an adequate law because it regulates also non-average LLC. This study adopts an incorrect premise as well. Let's do the same exercise looking for the average Brazilian person. Probably, we would conclude that the average Brazilian person is a young, white, heterosexual woman. What does that mean? Any law would be adequate if it only regarded the interests of a young, white, heterosexual woman. A law about racial quotas in university would be inadequate because the majority of the Brazilians describe themselves as white. Law would simply ignore the rights of elderly people, children, and teenagers because they are not the average Brazilian person. If a law protected homosexual man or woman, it would be unnecessary. Of course, the answer to all these questions is no. Definitely is no. So the FGV study clearly adopts an incorrect premise. We cannot accept the premise that a law would be adequate if and only if it regulates the average situation and ignores the non-average situations. The commercial code obviously needs to regulate all types of Brazilian LLCs. It cannot disregard any of them. Now, let's talk about the enemies. As I had said, those opponents see their interests threatened by the new law. Who are the enemies of commercial code? Who fears the commercial code? Who would be against the improvement of the Brazilian business environment? Who would be damaged by this improvement? The answer is the non-competitive businessmen and their firms. Non-competitive businessmen and their firms. It's quite easy to understand. If the Brazilian business environment improves, the competition increases. If the Brazilian business environment improves, much more foreign corporations, foreign companies will be interested in doing business in Brazil, and they will definitely compete with those who are already doing business here. Competitive businessmen or firms do not fear the increase of competition, but the non-competitive ones do. Mainly, the monopolists, businessmen, don't want to share the markets they have conquered with new players. The growth of competition will oblige them to reduce their profit margin. I would like to emphasize that competition is the way we have to guarantee better quality and reduced prices for consumers. I would also like to remind everyone that more competition leads to a raise in the workers' earnings. More companies will compete for the same workers, and the salaries will naturally increase. So, when congressmen discuss any new law whose goal is the improvement of the business environment, the congressmen arbitrate a conflict between the general interests of consumers, workers, and competitive businessmen and the interest of a few non-competitive businessmen. Enemies are strongly motivated to impede any bill. They can easily perceive the potential damage against their interests. But the people who will be benefited by the new law cannot promptly realize their benefits. For that reason, proponents need to spread the arguments of the importance and the necessity of the approval of the bill. The adversaries eventually may be convinced and change their minds, but the enemies, they will never be convinced. Finally, I would like to say that one of the most vigorous debates today in Brazil is about the opposition between the interest of a few firms and the general interests of the people. I refer here to the debate about the economical impact of the petroleum. As all must know, some of the largest Brazilian engineers firms have been accused of taking part in a huge bribery scheme involving Petrobras. Some people have been saying that those firms should be spared, even if their crimes are eventually proven. They shouldn't be condemned, because if those engineers firms were condemned, the Brazilian economy would stop. That's their argument. It is an argument very similar to the too big to fail we heard during the subprime crisis. In my opinion, this argument is wrong, deeply wrong. As Petrobras is prohibited from contracting with those engineers firms, it needs to look for foreign companies. Brazil will stop if we don't open our economy to foreign companies. The improvement of the Brazilian business environment is the best way to opening our economy itself. So, preserving the bribery-accused firms is just protecting their market share, not the Brazilian economy. When there is a conflict between the interest of a few firms and the general interest of the Brazilian people, there is no doubt we have to defend the general interest of the people. Thanks to everyone. Thanks.
Thank you, Professor Fabio.
Well, good morning. I would like first to thank Mariana for the kind invitation to be here today. It is a pleasure to have the opportunity to discuss again with Fabio the proposition of a new commercial code for Brazil. It is a pleasure to be here with Fabio too. And I have already prepared some ideas, some general ideas for my presentation, and I would like at the same time to answer some questions that were brought by Fabio. I would like, since I am not so proficient in English, I believe that it would be better if we leave this discussion to the debate part. I will focus on my presentation as originally planned. I believe that in this moment, we are still in a moment in which the most important thing to discuss is the theme of this debate. Is it a new commercial code for Brazil needed? Actually, I believe that it is important to answer this question without exploring the answers to another questions. Is it the legal strategy that is adopted in the projects that we are discussing now adequate to deal with the problems that we have in Brazil? Is this kind of solution something that we really need in order to improve our environment for business? And I would like to anticipate my answers. And from then you're going to find that I am among those that Professor Fabio characterizes as adversaries of the code. At least I believe I am an adversary and not an enemy. I wouldn't like to be an enemy, and it is something. And in my opinion, Brazil doesn't need a new commercial code, and the option for a principle-based code is a mistake. I am not an academic myself. However, my presentation will be based on some questions that, at a first sight, seem a little bit more theoretical. And I believe that this approach is necessary, considering the general nature of the discussion that we have now. As a matter of fact, I believe that a little bit more of theory would help us a lot in the discussions about the project of commercial code. I believe that even the belief in a new code as a solution for our problems, or as the basis for a solution for our problems, is something that should be analyzed more from a sociological point of view. First of all, I believe it is important to explore what is effectively a code, especially in the civil law regimes. In my opinion, the idea of a code nowadays is much more a kind of mythology that we adopt in legal field in order to convince ourselves that our systems are complete and rationally organized. I believe that the idea of a new commercial code for Brazil corresponds to this general mythology. Codification processes are directly linked to some historical movements. They are embedded in processes and in ideas from 16th and 17th centuries. The liberal framework, the consolidation of sovereign national states. Typically, a code consolidates laws that are in place in some territory, and it is important to remember the fragmentation of legal systems during medieval times, which was a problem for the new states in Europe. A code is considered the result of human rationality. It is built as a system, and it intends to be permanent, or at least not easily changed. The idea of a code is related to a specific type of society. During the 20th century, some amazing things happened. The function of law has changed. The abstractions and the neutrality of the traditional codes are no longer possible, or even desirable, as a matter of fact, in a world that is really complex. Law is nowadays an instrument for the implementation of public policy. It embodies incentive structures. It is more dynamic than it used to be 100 or 200 years ago. In this brave new world, is it possible to believe in completeness, systematic consistency, and endurance of the legal system? But it seems to me that the challenges are even more complex. One of the features of the modern world is the specialization in each and every area of knowledge. A lot of themes migrated from a general regulation by codes to special legislation. It is what an Italian author called the creation of microsystems. It is not difficult to identify this movement in commercial law. Professor Fabio made reference to it. Rules applicable to bills and documentary credits are one of the most clear examples. Banking law is another. In more dynamic markets, new themes are subject to state regulation or self-regulation, and not by general law, and not only by general law, as a matter of fact. Many times when we think on those theoretical divisions, those traditional theoretical divisions between the general civil law and commercial law, we don't even know if we are facing a civil law or a commercial law problem. We are, in general, facing a private law question, and sometimes it is not even so private, since nowadays the borders between public and private law are more or less blurred. It is totally understandable, then, that the Brazilian legislator has decided to consolidate all private law rules in one code, the Civil Code of 2002. Obviously, there are even in this option some relevant problems. But it is a way to reduce uncertainty in the relations between private economic subjects in general. Economic activities, entrepreneurial activities, what is more specialized is then subject to its own legal regime, considering their own needs. Considering these conceptual problems as a fact, and this is the basis of my explanation, it is possible to give another step and to discuss if, in Brazil, there is a concrete reason to have a new commercial code. Could a new commercial code in any way reduce uncertainties, legal and jurisdictional uncertainties that exist and that increase the costs of developing economic activities in Brazil? And the first thing to say here is that, in my opinion, these uncertainties have nothing to do with the fragmentation and with the dispersion of commercial law rules. Some of them are much more related to macroeconomic processes, FX rates, interest rates, problems related to the integration of Brazil in a globalized economy, and things like that. They are not resolved simply with the enactment of a new bill. But leaving aside these questions, is it really necessary to unify in a same code corporate law rules, bankruptcy, documentary credits, agribusiness, entrepreneurial contracts, some banking law issues, maritime law, and judicial procedures related to entrepreneurs? Is this what the economic agents really need in order to have a competitive environment? Not in my opinion. When the uncertainties that affect the economic activities can be identified as real legal issues, they are much more related to other areas, to other kind of problems. And this is documented in several researches and debates that we have been having in Brazil in the last few years. Tax systems distortions, deficient or inefficient creditor protection, obsolete labor law rules, jurisdictional uncertainty regarding certain issues, bureaucracy and the costs of bureaucracy in general. The reforms that we really need sometimes are really specific, and mostly they go beyond what we call commercial law. They involve even cultural aspects, our position regarding entrepreneurial activities and economic efficiency. A new commercial legislation doesn't help to solve these problems. It is only a formalistic and really specific solution, in my opinion. It won't change our way to deal with entrepreneurial activities, to make public policies. It will not create a new and modern generation of business lawyers. The only effect of a new commercial code maybe is then to ensure the existence of an academic discipline called commercial law. And another effect, it is to generate new and absurd costs. And I say this because that Luciana Young's study has already explored a little bit some of the problems that we may face. As a matter of fact, I don't want to talk about this study, but we have to take these costs into consideration, especially in our current situation when Brazil is facing a real need for fiscal adjustment, when we have the risks of inflation appearing again. There are several costs related to implementation and adaptation to new laws. There are costs related to consulting activities, and from a personal point of view, I really like these costs, and they are directly involved with my private practice right now, but there are costs related to litigation regarding the new rules, especially if we consider the reliance of the code on principles and general rules and standards. And these costs should be supported not only by the economic agents, but even by the taxpayers. It seems that nobody in the legal field is really concerned with this kind of problem. To conclude, up to this moment, a new commercial code is not important for the development of the country, and it can be even damaging to economic activities, at least in a short and medium term. It wouldn't face our real problems because it is a formalistic solution with limited scope. It would be artificial, considering the evolution of entrepreneurial activities, the specialization of these activities, and it would create more costs. The fragmentation of economic activity rules is not a distortion. It is a regular and natural process. In this sense, I would like to go a little bit beyond and to talk about the amazing variety of themes dealt with by the project of the new code. Actually, nowadays, you cannot find a common root, a common origin for all these themes. There is nothing unifying them to the point of justifying a sole commercial code for the country. And this deals directly with that traditional feature of the codes. They have to be systematic. For some of those technical fields, we already have systems really well consolidated. Maybe they need some periodic and specific reforms. It is the case of corporate law, especially company law. In other cases, we have recent and comprehensive legislation recently enacted. Our bankruptcy law is from 2005. In both cases, what is proposed by the project dilutes what already exists in specialized regimes. More than that, sometimes it ignores the theoretical constructions and the jurisdictional constructions that have been built in the last 20, 30, 40 years. Going in the same direction, the documentary credits regime that is typically fragmented, as I have already said, and that presents relevant difficulties for lawyers and for judges to interpret and to deal with, is not sufficient in the code to deal with the needs of a contemporary market that is marked by innovation. The debate regarding electronic instruments remains nowadays only in academy. New instruments are created all the time. They are adopted by market participants, and they are by nature flexible. And once more, the project creates overlaps and contradictions, especially in more basic institutes that are already submitted to civil code. For example, we will have two different regimes to deal with such an important concept as good faith. And talking about good faith, the principal innovation of the project, the fact that it is based in legal principles, in standards, in general rules, doesn't help much in the improvement of our economic and business activity, in my opinion. There is nowadays in Brazil a process by which legal principles are becoming more and more important. Nowadays, principles are considered as real legal rules. And there is a broad discussion about this kind of rule, about its effects, about its interpretation. I believe that principles are especially important in constitutional law when we are discussing human rights in general. It is something that raises from the recognition of the limits of the legal formalism in contemporary and complex societies. But considering the uncertainties that we have in the legal environment and in the business environment in Brazil, I am not sure if this is a good idea to regulate private economic activities, at least not when we are talking about private law. We need clear rules, we need transparency, we need predictability, we need to tame the excessive creativity of our courts. We need to facilitate the interpretation of law. These are the reasons by which I disagree with the idea of a new commercial code. We are not only in the 21st century facing challenges bigger and bigger. We need to overcome the excessive legal formalism and some of the myths that follow it, like the myth of the grand legislative solutions. This is, in my opinion, and considering the Brazilian formalistic legal tradition, our real task nowadays. Thank you.
Thank you, Otávio. Flávio, please.
So thanks, Mariana, for inviting me, and I'm thrilled to be in such an important debate with Professor Fabio Ulloa and Otávio Asbeck. And thanks everyone for coming. Yeah, my participation here, I think it will be more pragmatic than academic. I'm in the private sector, and more than that, I work at a corporation. So I'm faced every day with difficulties that corporations do face here in Brazil. And in my view, what we need is solutions, quick solutions, and stability and predictability, as Otávio was saying. And this is why I'm so concerned about this project. After this debate, not in front of all of you guys, I will ask Fabio if I am an opponent, but if I'm an enemy or an adversary, he will let me know later on. But I'm not going to ask you now, okay? So, but the point is, I think that the main question here is not only if we need a new commercial code, but is Congress here in Brazil in a better position than the private sector to decide what is best for business? That's my first question, which I think should be addressed with the few slides that I'm going to share with you about what is in there. First, to put everyone on the same page, I just wanted to let you guys know that when we talk about the new code, we're not talking about one bill of law. So we currently have two houses in Brazil, same way as you guys have in the U.S., but one of them, we have one bill in each of them. So one bill of law, which is from 2011, which was drafted by Professor Fabio Ulloa, has 670 articles. And the second one, which is dated 2013, which was drafted by a group of legal academics, led by Professor Fabio Ulloa, has 1,103 articles. So when I talk now, I'm gonna, again, sorry for not translating this. When I was a junior associate, I would do lots of translations. Now that I'm not, I'm done with it. So basically, I'm gonna go through some of the articles that are there, just to help the ones who don't speak Portuguese. I tried to at least put in English what we're talking about, and then I'm going to try to describe everything. But the main thing here is that the proponents of these projects are saying that they should be passed because they would improve legal certainty for the private sector, that they would improve the business environment, as Professor Fabio was saying, and that they would stimulate the influx of foreign capital to Brazil. So what I want to discuss with you in a really pragmatic view is whether these projects will achieve that or not, just by setting out some examples. And then I will try to conclude with my own view, personal view on this matter. The first thing that is that I think we should analyze is this article that says that every company, every corporation, every business should have a social purpose. This derives from the fact that in Brazil we do have a constitutional principle that talks about this social purpose of property. So every property should have a social purpose. What's the main reason for that? We were a colony from Portugal. We have huge chunks of land with few people. So if they're not using it, so let's take it from them and give to the ones who are going to use it. Okay, we have that since 1988. We're going to keep it. But the projects is saying that the basis, and Fabio Ulloa has said this in other debates already, that that from the social purpose of the property comes also the social purpose of the business. And then the project tries to say what it is. It's basically just trying to describe to you guys, saying that a company is meeting its social purpose when it creates jobs, pays taxes, creates wealth, and lots of other things. So my first question is, does this bring more certainty or not? Because first, this is not an issue in Brazil at this moment. We've never had, at least I've never seen litigation about this. So would we be bringing something new that will have to be debated among the academics for 10, maybe 20 years to define, okay, so what's really social purpose, and will we be facing 10 or 20 years of legal uncertainty? That's my first question. And what worries me the most is the fact that there's another article, another section here in this Bill of Law saying that the public prosecutor's office would be able to challenge and to try to go for the for nullifying the contract that is entered into two private parties based on the social purpose issue. So is this the kind of thing that will give more certainty or not? And do we need to grant the public prosecutor's office with more powers than they already have? And they do have lots of powers, and they do make a good job. But my question is, would they be interfering with private business too much? And moving on, there's this other section that I think we should think about a little bit more. It talks about the temporary judicial auditor. Sorry for a free translation. Just want you guys to get the picture here. It's basically saying that the judge may, upon request from a shareholder owning 5% of the company, to grant nominate an auditor who will have full access to the company, including books, records, and bank accounts. So basically, the company would be having, by request of a shareholder with 5% of the company, the company will be facing with someone who would be standing just next to it, to the management on a day-to-day basis, checking, are you doing everything right? Are you doing everything right? Two things that worry me here. The first thing is this the kind of thing that we want to have, like someone checking every little thing just because upon request of someone with 5%? Maybe yes, maybe not. But the second thing that worries me is when I think about the possibility of this leading to what in the US you call green mail. Basically, someone in bad faith could use this to just say, okay, I'm gonna use this, I'm gonna be in your business every day, I'm gonna be posing questions, be questioning everything, just to try to create so much damage that the company will just say, okay, I'll pay you out, I'll pay you 100 million reais so that you can give me back the 5% that maybe fair market value would be 10 million because it's costing me so much more to have you here, then that's just leave. So this is the kind of uncertainty that I think would be brought with this. Moving on, the code, and every time I make reference to 2011 on the top, so we're talking about the Bill of Law that is in the lower house, and when I talk about 2013, we'll be talking about the Senate, okay? So in this project, this Bill of Law, it has created a principle, as Otávio was saying, that he is against about having a principle, and I agree with that. And this principle here talks about asymmetric treatment among contracting parties. So my first view is that usually in the private sector, you always think that private parties are in the same position. You cannot, it's hard for you to say, okay, who is in best position when they are negotiating this? It's basically a case-by-case situation. But here, it's basically saying that whoever is economically weak would be protected. And one of the examples of how this would work is Section 313, when it's saying that if one of the parties is a micro business, we do have this legal concept here in Brazil, or a small business, another legal concept in Brazil, and one of these parties is dealing with someone who is a corporation or not even a large corporation, just someone who's not a small business or a micro business. The one that is allegedly in the best economic position, the larger corporation, would have to make clarifying alerts every time this large corporation notices that the other one may not be understanding something in the contract. So I think that the purpose of this has its merits. It's basically just making sure that, okay, if you're entering into this agreement, you will understand everything that is on it. But the point is, how could this be used by someone in bad faith? So let me just say, in addition to dealing with corporate and M&A, I'm responsible for all of the contracts, the thousands of contracts that my company does every year. So let's say that I gather my team and just say, now our contracts will have big letters. They're going to be straightforward. We're going to have bullet points. It's going to clarify. We're even going to have some pictures, some drawings or something. Whatever it is, there would still be room for someone to go on court and challenge by saying that it wasn't enough. And that doesn't, in my view, create legal certainty. Then, something that is really good for lawyers, but again, I'm different. I'm not in the private sector. I'm in the private business, so I'm not going to profit from there. The project is implementing discovery in Brazil. And again, I think people in the U.S. know how costly discovery is. And just for those who are from Brazil, discovery is basically saying that one party should present to the other all of the documents related to the project, if they are to the benefit of the party who is presenting them or not. And when you become a lawyer in the U.S., you even have to give an oath, and one of the things that you're saying is basically that you will be acting on behalf of justice. So when I passed the bar and I took my oath, I did that in front of a judge in New York, because I am now a part of the justice. I'm acting on behalf of justice. It's different in Brazil. In Brazil, you're acting on behalf of your client, and you have some legal ethics and legal principles. But we have also one thing in the U.S. that is the fact that legal representation in the U.S. is really costly. In Brazil, it's getting every day more costly. And I have one example, someone who works with me who is also U.S. licensed. She used to work at Simpson Thacher, huge law firm, 500 lawyers only in New York only. And she told me that for a couple of weeks, there was a discovery process going on that led to almost everyone in the firm stopping what they were doing to go through the documents. We're talking about when I was a junior, first-year associate, my hour was almost $400 an hour. If you're talking about the whole firm, try to think how costly that was. So now try to bring this, when you try to bring this to Brazil, we have another problem. In the U.S., only a small fraction of the litigation even gets to discovery. Maybe 90% don't get it, or even more, because there's so much that you can do until you get to discovery. You have to prove so much until you can get to discovery that almost everything is either settled or just dismissed by the judge. In Brazil, it's different. In Brazil, the judges basically don't look at a legal proceeding until all of the documents are already there. So different from the U.S., where you would have maybe 1%, or let's say 10% of the legal proceedings reaching discovery. If we implement discovery in Brazil, it would be for each and every legal proceeding, with all of the costs related to that. And again, talking about bad faith, what about someone that would just bring a lawsuit to try to get access to information from a competitor, using the example that Fabio was giving, just to get the information in bad faith and use it in bad faith? What about that? How can we prevent that from happening? So the code, the Bill of Law also brings this new entity called the facilitator. That's basically the best translation I could get. It's just saying that the judge could, whenever the legal question posed by the legal proceeding is complex, or when the legal proceeding is too big, it's talking about like 500 pages or more, the judge, based on one of those things, can just nominate someone, whoever he thinks is suitable, to basically analyze the whole process and bring him a report of all of the evidences that are there, and of what has happened in the process up to the end, up to the time when the judge should decide. So it's basically saying that someone will be trying to analyze everything to the judge and say, Judge, if you read this, you can decide. Of course, you can always go through the process yourself, but if you read this report that I have made, this 10-page report that I have made, you can decide. My question is, would this be proper? Would it be proper to have someone who does not have the constitutional legitimacy of a judge he's not going to decide, I know that, but to analyze everything for the judge, and second, the parties who would be paying for this would be the parties involved in the process. It's not something that the facilitator would not be doing this for free. So the judge would set his fees, and the parties would have to pay 25% up front. Okay, and so my question is this the best way to approach this? Would this be creating increasing costs? But again, let's move on. And just to show you guys that in the 2013 Bill of Law, again, both of them are in discussion, being discussed right now. So it's really hard for us to say, okay, where should I send my comments to the Senate, to the House to the House? What should I do? And again, in the Senate, there's also asymmetric treatment of contracting parties, but now it's different. Now it doesn't talk about the weaker party, but it talks about the dependent party. So if my understanding is correct, what it's trying to say is that if one party depends on the other at some level, this party should be benefited when analyzing the legal question posed. My question is, okay, when can you really say that someone is dependent on the other? Maybe it's clear cut in one case, maybe it's not, maybe it's blurred in another. And again, is this the best way to deal with private litigation between two private parties? So again, just food for thought. Now, the project in the Senate also brings another principle, and I'm trying to bring it pragmatic about the principles, that is bringing the possibility of the judge analyzing externalities in its decisions. It's basically saying that the judge should always take into consideration economical externalities in its decisions. I think, again, if you think about the concept, it's a good thing. Okay, so the judge, when he decides, maybe he's thinking of something here related to this process, but which could have huge impacts in other areas. My question is, first, are the judges in best position to evaluate economical externalities of their decisions? And second, couldn't they also be using this article, this principle, to decide maybe against the law, or to divert a little bit the interpretation, how the law is being construed, just by saying, no, but look, the law says something like that, but in this case, there could be an externality, and I believe that the right thing to do is to do the following, which is totally against the law. Where's the legal certainty on this, right? Then another thing that is brought by the project in the Bill of Law in the Senate is the possibility of the judge granting punitive damages in case one party violates its duty of good faith. First, good faith is always debatable. I think it's an important principle, but it's always debatable. Okay, when do I violate my good faith duty or not? Second, punitive damages. I worked with Professor Coffey in the U.S., and he always said that punitive damages is one of the reasons why there is so much litigation in the U.S. I think that after spending a few days in Brazil, I do know that you guys, that the Americans here have visited a number of corporations, and everyone who is Brazilian know that. You know how much litigation we have in Brazil, and we don't have punitive damages. Try to think of what would happen if we did. But again, the judge may just decide that one party would be entitled to punitive damages due to the breach of the other party's duty of acting in good faith. Again, let's food for thought. Let's think if this gives more certainty or not, right? And it's also bringing a broader possibility of derivative suit. We do have derivative suit in Brazil. It is basically limited to corporations, and it's basically, it's really restricted how it can be used. You have to at least either post a bond when you enter, when you bring such a suit, or you have to have a relevant portion of the company to be entitled to bring such a suit. And with the project, what the Bill of Law is basically saying is that any shareholder, even a shareholder with one share, could bring a derivative suit on behalf of all of the shareholders and of the company at any time, just like it's in the U.S. In the U.S., it's just like that. But the thing is, in the U.S., it has been a problem. Consistently, it has been a problem. So much that in 1995, the Congress in the U.S. passed the Private Securities Litigation Reform Act, which was basically trying, first, the Title I, it was aimed on reduction of abusive litigation. This is the thing that I think could happen. Basically, whatever happened in the news, if some company did something wrong or something went wrong, the company did not do anything wrong, but something went wrong. First thing that someone maybe in bad faith or maybe thinking that he's acting in good faith would do, he would just say, okay, let me find a shareholder from that company, let me get a proxy from him, and I'm gonna bring a derivative suit day one, right now, so that I'm gonna be the lead attorney on this. My question is this the kind of control that we need in Brazil from small shareholders? I think we in Brazil have the great benefit of having the CVM with its in my view, the best governmental branch. It's not the right real term, but in Brazil. And do we need extra control from really small shareholders with one share that maybe their interests are not aligned with the interests of the company? And what's worse, in the U.S., the companies and management, specifically management, has to its benefit the business judgment rule, right? So the court will basically look at the decision that was made, and if management did everything they should, their fiduciary duties were met, basically, okay, wrong, you did wrong. Just like the Walt Disney case about the CEO, retaining a CEO, paying $150 million for the guy to stay 1 year. It was a really bad decision. Walt Disney suffered a lot, but basically when the Delaware court was analyzing this, they just said, okay, they took the decision, meeting their fiduciary duties. They were informed, they were acting in good faith, and so on. So, what about here in Brazil? We don't have business judgment rule in Brazil. That's one. Second, liability in Brazil, it's basically the following. If someone has been damaged, and if someone did something that led to this damage, this person is liable. That's basically it. So if you add derivative suit with this kind of liability we have in Brazil, D&O insurance will go skyrocket, rocket, and also maybe people will start charging more for being CEOs or CFOs, or maybe they'll just say, okay, I'm not gonna be a CFO. I'm not gonna be a general counsel. I'm now gonna be in the private sector suing everyone because I'm gonna be facing less risks and getting more money out of this. Oh, and there's one thing that is really interesting. The corporation that is being sued will have to send a notice to each and every one of their shareholders notifying that the company is being sued, and the company will also, if it's a public company, will have to do the same on the internet. So for each and every legal proceeding, even if it's not, there's no proper basis, the company will have to do that. So moving on, now we talked about the auditor, the judicial auditor in the beginning. The bill in Senate talks about judicial intervention now. So now it's again the 5%. Now it's trying to say that, okay, but the person with 5% will have to prove that the company will have to show that there is a fear that the management has practiced or may practice something in the future that will be harmful to the company. Again, really blur where this stands. And second, what's worse, now this person that is nominated by the judge will not only be there to audit what's being done, but it will basically take over the management, the day-to-day business of the company. I joked that in my company I was working hard to become the CEO one day. Now I'm just going to try to get 5% and sue him and get this done. So maybe it's a way to get there. And last thing that I wanted to bring to you guys as examples are the treatment for foreign creditors. It's basically, so we were talking about giving legal certainty. We talked about stimulating influx of foreign capital into Brazil and everything. And when you talk about foreign capital, foreign investment, you're not just saying, okay, foreign companies should come and open new branches or something like that. You're also talking about foreign companies giving Brazilian companies, or maybe foreign companies that are in Brazil, more money to do what they're doing in Brazil. Here, the Bill of Law is saying that the foreign creditor will be paid, in case of bankruptcy, the foreign creditor will only be paid after all other creditors have been paid. So what's the message we're passing to foreign companies in Brazil? Please don't pass along this message, okay, when you go back to the U.S. But what's the message that we are trying to pass along when we put something in a Bill of Law? So that's what worries me. So my view is that instead of creating a new commercial code, which was not requested by the private sector, I can assure you guys, I've never met some company that said, okay, I want a commercial code. I hear every day someone saying everything that Professor Otávio said about legal certainty, about tax challenges, and so much other things, labor law in Brazil, but never about the commercial code. So instead of creating a new commercial code, I think that Congress should focus on small changes to existing laws that would have a greater positive impact to the company without the unexpected consequences of passing a new law with over 1,000 articles. So that's my personal view on this, and I hope that this helped you guys get a better picture of what we're talking about.
Thank you. Great. So now we have time for Q&A from the audience. Does anyone want to start? Great. So, okay. Please, Rafael.
Regarding the FGV study you mentioned before, although I was not involved in this research, I guess their point was not that we shouldn't regulate only the average limitada, but we should, by establishing the 4 rules that would be able to accommodate this situation, because the code, the bill, brings some sophisticated matters on the limitadas, including the shotgun mechanism. And I guess their point was just to say that we should have, okay, this is a possibility, but the 4 rules should be more simple, and then if the parties want, they can get that away. The second thing that I would also like to comment is that personally, I don't like to think that there are enemies to the code. I think that we're all trying to, there's no us and them, we're all trying to contribute to a better commercial law. And even though there are some more propositive ways to address it, like the study from the FGV saying, oh, we should have the 4 rules which should be more simple. I guess even the so-called enemies are also proposing something when they say, like when you can choose black and white, when you say, well, this can't be black. Or even though we know everything is not black and white, we have yellow, blue, you say this can't be white, you're saying, well, we have some other possibilities. And I mean, in a democracy, from the political point of view, the most important right, it seems to me, is the right to vote for a candidate, for president. We don't have to, let's say, motivate, I'm voting for this, but when we voted for this, you're saying at the same time, I do not want that.
Even who is against the commercial code bill agrees with the necessity we have nowadays in Brazil to change the regulation of the LLCs. And I don't agree with only simple rules will be a satisfactory solution, because we have very large LLCs. We need sophisticated rules to these LLCs. And the conclusion I said about the FGV study, the commercial code would be adequate because it regulates only the doesn't regulate only the every LLC, is what I heard here in this room when the study was presented, was shown, I don't know, 2 or 4 months ago. So this is the conclusion of the Professor Matsuilho. Okay. And about the enemies, of course, I would like to agree with you. I would like to live in a country without enemies. In a country where only competitive businessmen stay here. If in Brazil we have only competitive businessmen, our economy would be much more better. But the enemies exist. I would like to live in a country where all the entrepreneurs would have a collaborate attitude, behavior. I don't know. Sorry if my English is not enough to specify my idea. But it was more or less clear. Oh, okay. Flavio is helping me with the English because my English is not so good.
Hi, I hope my English is good and it's understandable. So I'm one of the folks here visiting from Stanford, and I just want to tell you how much I appreciated your comments, all of you, and learned from them. It's such a wide-ranging, as the comment has been made, such a wide-ranging code, and it would seem to me to be impossible to talk about it in the course of a couple of hours that we have here. But one of the things that I found remarkable about this discussion is how coherent the debate has been among the three of you, and I have a great sort of sense generally about where the positions are, and so I'm imagining you've rehearsed this before because it came across extremely coherent. So I can see arguments on both sides, really strong arguments on both sides. And so instead of getting into the arguments, I just wanted to maybe present slightly different ways of framing some of the issues that I've seen appearing here. One of the issues is whether we like principles or rules better, standards or rules better, and that's a big issue in law and in legal regulation. And I personally think that there is a lot to be said for both standards and rules in different contexts. The way I think is useful to frame this, especially in contracts, is who ought to decide which is better, whether it's the private parties or the legislatures or the courts. Standards, the way we think about it in the U.S., standards really, it's about delegating lawmaking to the courts as opposed to the legislature. When the legislature passes a rule, the legislature has made a decision about the content of that law. When the legislature passes a standard, they're basically delegating to the courts the decision about the content of the law. So the Article 2 of the Uniform Commercial Code that governs sale of goods laws has a lot of words in there like reasonable, commercially reasonable. And what this is really is the legislature is saying, we can't decide because there's so many different contexts on the sale of goods, and therefore we will delegate to the court in any particular time to make that decision. And sometimes that's a reasonable thing to do, using the word reasonable again. However, the parties themselves can make that decision. And you can't be critical of good faith as a general principle, because what you see in many contracts is the parties themselves write good faith. You know, that the seller shall always act in good faith. The seller should always act in a commercially reasonable manner. And what they are doing there is what they as well are deciding to delegate to their courts that will decide their disputes, what is the content of the obligations. And they have a choice as well, the contracting parties have a choice as well, to be very specific about what they require, or to say, you know, there's so many different environments that we could be performing in, therefore we want to delegate to the court. I personally think that there's a lot of advantage when you have a strong bargaining process, a reliable bargaining process, to let the parties themselves decide whether good faith is something that they want to bring into their relationship or not. And in particular, to decide themselves whether they want to delegate to a court the decision about what constitutes good faith, or whether they want to put more detailed requirements in the contracts themselves. So, reframe it not as we like principles or we like rules, but who should make the decision about the content of the law? The legislature, the parties themselves, or the courts. Now, I think that the quality of judicial decision-making or of the dispute resolution is an important factor. The higher the quality of the courts, the higher the quality of the arbitrators, the more likely it is that either the legislature or the parties themselves might say, we'll leave it to the courts to decide later on. So there have been some studies that have shown that when franchisors, in franchise contracts, when they have an arbitration by experts, they're more likely to use principles or standards than when they have the courts, because they figure it's a more expert arbiter than the courts. So that's the first framing sort of decision or reframing that I wanted to propose. The second one concerns the regulation of the contracting process after the fact, which is looking back and thinking about inequality of bargaining power, lack of sophistication, lack of information. And I wanted to just note a couple of reasons where one has to be very careful in talking about weakness and inequality of bargaining power, and in particular, keep it very separate from information, which I think is the real problem. An example that is often given in class is, and some of my students have heard me say this before, is supposing you have a monopolist that is the only seller of cars in a town, in an area, and can present to the customers a take it or leave it offer. Do you think it would make sense for that monopolist to say, I only sell black cars, take it or leave it? The answer is no, because what the monopolist should do is say, tell me what color you want, and I'll give you that color at a price, a monopoly price. So we say that the monopolist extracts the monopoly rents through price, not through the color of the car. Same thing with a warranty. Do you think a monopolist who's selling a car would say, I'm only selling a car without a warranty? The answer is no. The seller of the car would say, I'll give you whatever warranty you want at a price. And indeed, when you look at the debate about market power in the United States and you compare it from the 1960s and 70s at that time the problem was perceived to be that car manufacturers didn't give warranties or appliance sellers didn't give warranties. And why is that? They said, well, because they've got all the bargaining power. They can say, take it or leave it, and we don't give any warranties. Now, you know what the problem is? People are buying too much warranties. They're buying extended warranties. So, because the idea is that market power means you sell as much as you can, warranties, anything, as long as you can make money off of it. And so if you could say the same thing about arbitration clauses, about dispute resolution clauses, about everything in a contract. So even a monopolist would give contract terms, non-price contract terms, that represent the demand, that respond to the demand of the consumers. The real problem is that the consumers don't know. They don't understand the terms of the contracts. And it's also true regardless of inequality of bargaining power. One party or another may not understand the contract. And so in the restatement of contracts in the US, there's a provision that says that when two parties contract and they have a different understanding of the contract, then if one party knows that the other one misunderstands the contract, then the interpretation that governs is the interpretation of the party who was misunderstood, but where the other party knew it. In other words, there's a responsibility on the party who's better informed when they have a chance to correct the misinformation, the misunderstanding. But notice it's not based on bargaining power. It's just a way of correcting misunderstandings in the contract. It raises the problem of litigation and unpredictability and so on, but there's an economic efficiency underlying it that is aside from economic weakness or inequality of bargaining power. Why do I say that? I say that it's important to understand what is the real problem that we're trying to get at, and sometimes when you put a lot of these together, especially inequality of power, weakness, market power, and so on, whatever it is, I think it's a dangerous, you blur issues very much when you use that. Sorry for taking so much time, but I wanted to propose those ideas. Thanks.
If I may, I would kindly ask you to, if you can, like extend a little, expand these thoughts a little bit further. If you have some time later on, not today, but like, if you do have some thoughts on what we have been discussing, and if you find something interesting, because everything you were saying is really going to add the debate to all of us. For example, on the restatement of contracts, this is a very good idea, and the concept itself is very interesting. The only problem that we have here in Brazil is one thing, and this is one thing that we should always discuss, is because when you the laws here in Brazil usually do not give room for the parties to just say, okay, I'm gonna disregard what's in the law, and we're gonna decide among ourselves. So that's one of the main issues that we face. So even if the parties do agree, this is in good faith and everything, if something changes in the future and someone wants to challenge, they can always go back to the law. So this is one of the problems we face, but I would just like to thank you for this, and if you can share anything on that to us, I will just kindly ask Mariana if you can share with her just to forward to us. Okay? Thank you very much.
So I was very, I wasn't aware, in fact, about one of the last issues mentioned by Flavio, which was the fact that foreign creditors would come last in a bankruptcy proceeding. And I just wanted to understand more what the rationale for this provision is in light of the stated goal of promoting foreign investment in Brazil.
The UNCITRAD, the United Nations Commission on International Trade Law, has a model law of transnational bankruptcy. It's inspired by the North American law. It's a model law that establishes the cooperation, direct cooperation between the judges, without the necessity to involve the foreign affairs ministers of the country, rogatory letter, carta rogatória in Brazil, rogatória, direct talking between the judges. Brazil is the only country in America that doesn't have in its law rules reproducing the model law of transnational bankruptcy. This kind of rule is exactly what you see in this law model of UNCITRAL. The idea is that you don't have international jurisdiction in bankrupt issue. You have a cooperation, an obligation that is not executed in a country, remains with this characteristic. The judge can talk directly, but in first time, you execute, you satisfy the obligations regulated by the law of that country. If remain assets, you can offer these assets, the judge can offer these assets to the other creditors, the foreign creditors, which credit is regulated by the foreign law, not by our law. Was I clear? No. It's the same rule UNCITRAL recommends as the best rule for transnational bankruptcy.
Professor, and we know now where it comes from, but wouldn't it be against the Article 5 of our Constitution that says that everyone is equal before the law, and then only to political rights that we can differentiate foreign people or foreign capital? I mean,
No, it's not against our Constitution, because the credit is not enforcement in Brazil. Okay? The equality is to treat equally who is equal. If you have obligation enforcement in Brazil, and you have an obligation that isn't enforced in Brazil, no, they are not equal. Okay. May I say something? I would like to talk about the legal uncertainty or legal certainty and the principles. In Brazil, currently, we don't have the commercial law principle enacted in law. The commercial law principle hasn't been said by the legislator, but the consumer law principles, we can find them in the law. Some standards in civil code, like the good faith, like the social function of the contracts. So, as the Brazilian judges have decided, have ruled based on principles, when they don't find the commercial law principle, they rule based on non-commercial law principle, based on consumer law principle as well. And in a lawsuit between two entrepreneurs, judges decide this lawsuit based on consumer law principle. Okay, it's happened. It's happened. We need a commercial law based on principles because we need to express the principles compatible that match with the commercial law litigation. And it's necessary because ideology matters. Ideology matters. In Brazil, we have a precedent, a very interesting precedent, related to the same-sex marriage. The Constitution, our Constitution, is the same since 1988. The same rule exists in our Constitution about marriage since the 1988. In the past, the same rule was interpreted as a rule that forbid the same-sex marriage. In 2012, the Supreme Court changed this interpretation and ruled that our Constitution is compatible with the same-sex marriage. Our Constitution protects the same-sex marriage. What changed? What changed during this time from 1988 to 2012? It wasn't the law, the norm, the Constitution. It's the same. What's changed was the ideology of society. When Otávio said that we are facing a sociological issue, I agree. I completely agree. We need a code. We need a code because we need to change the ideology of the judges, of the Brazilian judges. We need a very strong instrument to change the ideology of our judges. Our judges need to know, to realize that in a business contract, they can't rule based on a consumer law principle. And this impactful event, only a code in Brazil, in a jurisdiction, in civil law jurisdiction, only a code can provoke, can do.
Has a comment or questions.
I would like to make some remarks, and first of all, I'd like to say that I am not against the use of principles or general rules. The adoption of a good faith standard by the Brazilian Civil Code of 2002 was something that really helped the interpretation of complex contracts, and I believe that this kind of solutions have their importance. But I believe that their main problem when we are discussing the project of a new commercial code for Brazil, and a commercial code that is declared as a principle-based code, is that what Professor Fábio thinks is a quality, I think it is a problem and a risk. And I believe that maybe we shouldn't take this risk. I believe that principles really open the door for the ideology in the judgments. And I believe that the example that was given by Professor Fábio of same-sex marriage is perfect for this. As a matter of fact, I believe that this example is perfect for more than one reason. First of all, because it is in that field in which principles are really important. When we are discussing same-sex marriage, we are discussing equality, we are discussing human rights in its essence. When we are discussing a relationship between entrepreneurs, I am not so sure if it is so important to open these doors to ideology. Of course, we will always have space for interpretation. We will always have an important position for the judge in the definition of what is the law applicable and what is the real content of the law. But I believe that having a code based on this idea will not help much. And more than that, I believe that this opening up to ideology is probably is not going to be an opening up to a new ideology, more business-oriented or something like that, considering that our judges are formed in law schools, in traditional law schools, with some ideas and a cultural framework that is not much prone to business. So I think that opening the door to ideology is always needed in complex societies nowadays. It is the fruit of the recognition that law is in some sense a social fact, and I totally agree with that. But I believe that it is not a new bill that will solve the problems and that will change the ideology and the way we deal with business.
May I just add two related points, and I'm sorry to take advantage of my position at the table here, but it's just such, this is kind of Disneyland from a contract and commercial law professor to be here and be able to have this debate. So I had heard Professor Coelho's description of the constitutional law question concerning gay marriage before, and had the opportunity to ask this question before, because it seems like the ideology factor in that specific case actually cuts against the enactment of a huge code. In fact, it was possible to see massive legal change without the change of a single provision in the law. So why would we change 1,000 provisions in the law without careful deliberation? Because of course it's very hard to have educated debates about every single one of those provisions if the objective is to shape ideology. And in that respect, I'm actually puzzled by the fact that this proposal comes from Professor Coelho, in fact, the most widely read author in Brazil, and who's therefore very well positioned to, I think, influence ideology without the need necessarily for a commercial code. And another part that puzzled me a little bit about the project, I actually agree with Professor Trent, is that a lot of things to be said in favor of principles or against principles. I also take Flávio's point that in Brazil, we usually don't see good faith as a default rule. It's usually a mandatory rule, so the ability of parties to contract out of those principles is, by our mindset, necessarily limited. But there were two things about the principles that puzzled me a bit, and therefore I would love to hear Professor Coelho's reaction. The first one is that the code is usually sold as a defense of principles, but there is a rule, and I think there's something to be said about that. I respect that view. But then there are lots of principles described there, and at the same time there's a provision which is very unique in Brazilian law, does not currently exist, saying that no principle should supersede any legal rule. And then I'm like puzzled. I mean, do we like principles or don't like principles, and how do these two views interact? And then because so I just don't see how that relates to the defense of principles, having this type of rule. And the second part relates to the defense of commercial law principles that Professor Coelho was mentioning. And I just wanted to know, what are the principles that are truly commercial? Because in my mind, a concern about protecting the weaker party traditionally has not been a general commercial law principle, but a principle we associate with other areas of law, such as labor law or consumer protection. So I just wanted to know, the essence of those commercial law principles that the code wants to promote.
Okay, I will try with my poor English to react. First of all, to Professor Yazbek, we have to take care about the principles. Just say the principle. Just say the principle. The social function of the companies, corporation. It's dangerous. Just say the principle is dangerous. Because it's an open rule. Judges can see several different things in this open rule. But the Commercial Code Bill adopts a strategy, a unique strategy, in order to control the danger related to the principle and other standards. What is this strategy? The Commercial Code Bill say the principle, enunciates the principle, and after that, each principle is precisely definite. But what's the idea? Those principles, they already exist in our system, in Constitution, in the precedents, in the ideology, doctrine. We need to precise this principle. If we ignore the problem, oh, the principle doesn't exist in commercial law, we will have judges ruling, adopting wrong principles. We need to face the problem directly. Say the principle and precisely, and say precisely what it means. Each one. This is a strategy, in my opinion, very clever strategy the Commercial Code adopts. And why, Professor Pargendler, why we need a code to spread out ideology that our judges apparently forgotten? Why a code? In fact, we have two different alternatives to spread out a new ideology in a legal community. First alternative is, I will call this alternative the academic alternative. We produce theses, articles, lessons, teach our students, and promote seminars, of course, etc. And this alternative, we have adopted it since, I don't know, since I was a junior in law school. And nothing happens. Why? Because in Brazil, the legal community unfortunately think that only what we see in the law, is something to study. I will study just the law. If the commercial law principles are studying in a book, in a thesis, it's not for me. I will study the law. When a commercial code brings the commercial law principles in the law, it will become a subject of our reflections. the new judges will have to study this principle. You have to incorporate the value, the ideology related to these principles. The principle that protect the weaker part. This principle, it exists in the mind of all of Brazilian judges. All of Brazilian judges nowadays think that protecting the weaker part of a contract is their main task. That's the value all our judges incorporated. We need a law regulating this protection as the Commercial Code Bill. The Commercial Code Bill say much more than Flávio shown here. The Commercial Code Bill say that the weaker part don't have the opportunity, the alternative to be protected if it make a mistake in its decision. He lose the protection if he make a mistake when he signed the contract. It's a control of the principle of the weaker part. It's a control we have to stop our judges when they rule based on other principles. About the hierarchy. Principle or rules. What's of these norms is the hierarchically superior. All the philosophers and theorists of law, all of them have the same concept. The rule must prevail when it's contradictory to a principle. If you take Robert Alexis, I will try in English. Principle is a norm that you apply, that it's applied in the largest field possible. You stop to apply a principle when you face a legal barrier, a legal obstacle, which is a rule. So, one of the most dangerous things that we have in Brazil currently is the wrong idea that the principle would be hierarchically superior than the rule. It's a wrong idea. The correct idea is the principle the principle isn't applied when you have a rule, a specific rule. You apply the principle when you don't have a specific rule. This is the order of the strategy the Commercial Code Bill adopts to control the principle argument. Because without control, we don't have legal certainty, okay? But nowadays, we don't have control. We don't have the principles controlled nowadays. We need to control. We need to control the principles in order to obtain more legal certainty. And the Commercial Code is our best instrument to do this control. And I forget.
Thank you. I think just Flavio wants to, we are about to run out of time, but Flavio wants to react, so
Yeah,
please.
Just to chime in, and again, with a pragmatic view. So for academic, go for this, guys. Don't look for me. But first thing is, in my view, it's a little bit conflicting, is when you say, is this idea that code will set principles, but at the same time it will limit them so much. In my view, it just becomes rules. And again, so again, I'm not in favor of principles for business. I'm in favor for human rights, for citizen rights, whatever it is. But I'm not in favor for business activity. That's my view because of what I have said about standards not being able to be ruled out by the parties. But again, there is, in my view, a conflicting stand when you say that their principles are there, but they are very limited. So this is my first view on this. Second, about the point that professor was saying that, okay, but when the weaker party makes a mistake, the weaker party cannot challenge the decision and so on. So, but the thing is, when can one say that a mistake was made? That's one. And second, and that it was not due to the fault of the party which was in a stronger economic position. So again, and this economic position, the way to decide, as Professor was saying, and I totally agree. I really like the idea of the restatement. I'm going to take a look at it. To add on what Professor is saying of how can we make judges think differently about the code, I would just add a third alternative, which is the one I adopted. You could marry a judge. So I did marry a judge, and Professor knows that. And I talked to her a lot about commercial law. I love commercial law. I read it to go to sleep at night. So I do. So, but jokes aside, again, a pragmatic view. I asked her about this concept. Okay, so would judges think differently of commercial law if a code is passed? And she said, no. Why would I? A code is just a law, but it's just a bill of law with the name of a code. So it's not going to change anything. That's what she told me, and I think she's a great judge, so I really rely on her. But, and second, I don't agree with the concept that every judge in Brazil decides in favor of the weaker party. My wife is a labor judge, which is in Brazil is well known for someone who will decide in favor of the weaker party. But she always tells me she does not decide in favor of the weaker party. She decides in accordance with the rules of evidence. And the rules of evidence in labor law in Brazil is basically saying that the employer is the one who should bring all of the evidence. And again, in Brazil, we know how informal things are. In Brazil, we know how hard it is even for a company, for a firm to make sure that it's doing everything that the law is saying. But basically what she's doing is applying the rules of evidence. So if the employer does not bring evidence that he did everything he could, she's going to have to rule in favor of him. So what we should do is change the law in that respect if we wanted to have something like that. And maybe it's not the case for labor law, but in my view, it should not be the case for commercial law. So that's just my...
Yeah, so we are monitoring some courts. We don't have the numbers already. Perhaps I can't say that now, but we can realize, we can note, we can measure some difference in the decisions since the Commercial Code Bill was introduced. Since the bill, just the bill, only the bill, it has been enough to change some decisions. Some judges in the highest courts of Brazil, Minister, has adopted the bill, has make reference to the bill in some rules to make to show the ground of this rule. We are monitoring the situation. We don't have now numbers to show, but I think in the future, I hope in few months or 1 year, I hope we can show numbers to present that ideology matters. Ideology matters. Just the commercial code bill has changed the things.
Well, I think we are out of time, so just please join me in thanking our panelists for a wonderful debate today.